Duration of an offer. An offer does not continue indefinitely. An offer will last until one of the following occurs. It is accepted. As an acceptance of an offer terminates the offer with the effect that the offer has ceased to exist in order for there to be an acceptance. It is rejected. When an offer is rejected, it is terminated, therefore it cannot be accepted. Hyde and Wrench is a significant contract law case that emphasizes the principle of counter offers terminating an original offer. Here are some key points from the case. So the original offer was that the defendant offered to sell a farm for £1,000. The counter offer was that the plaintiff responded with a counter offer of £950. Termination was that the court held that the plaintiff's counter offer terminated the original offer. Therefore, there was no contract since the original offer was no longer valid. The plaintiff's subsequent acceptance of the original offer was ineffective. Rejections are not effective until communicated to the offeror. It is revoked. An offeror is free to revoke at any given time before acceptance. In the case of Payne and Cave, it was established that an offer can be revoked at any given time before the offer is accepted, as there is no legal obligation until acceptance takes place. The 1828 case of Routledge and Grant establishes the principle that if someone offers to buy your house and gives you time to decide, they can change their mind and cancel the offer before you accept. This is to make sure that they can't back out. You need to have a separate agreement where they promise to keep their offer open for a set time. If they break that promise, then you can take legal action. It lapses. In a setting where the offeror has not mentioned a specific time frame, the offer will lapse after a reasonable length of time has passed. This decision will of course depend on the circumstance. For instance, offers to buy perishable goods and items in which prices fluctuate daily. These will lapse quickly. The case of Ramsgate Victoria Hotel Limited and Montefiore, 1866, is a landmark case in English contract law that establishes the principle that an offer can lapse due to a delay in acceptance. The principle is based on the idea that an offeror should not be kept indefinitely in a state of uncertainty. Death. Where the contract will require the personal services of the offeror, the contract will automatically be terminated. However, in the circumstance of the contract not requiring personal services of the offeror, then a personal representative of the offeror may have to employ somebody else to do the needful.
Get somebody else to do it.
Acceptance. When an offer is accepted, it becomes an agreement. Professor Treatle describes acceptance to be, and I quote, a final unqualified assent to all terms of the offer. This is judged by an objective test. For instance, evidence must be brought forth from which the courts can prove an intention by the offeree in regards to acceptance to the offer expressed to them. The mirror image rule comes in play. This, in short, is a principle in contract law that means acceptance must exactly match the terms of the contract. For instance, yes, I agree to buy your car on the terms you have stated. An acceptance of an offer can be implied or expressed. Acceptance can also be implied by conduct, as shown in Brogden and Metropolitan Railway Company. Implied acceptance is most likely to occur in unilateral contracts such as Carlisle and Carbolic Smokeball Company. Please note that if any new terms are introduced or there are modifications to the terms of the original offer, then it becomes a counter offer and not a qualified acceptance, as a counter offer destroys the original offer, as shown in Hyde and Wrench. The general rule of acceptance is that it must be communicated to the other party. However, with that being said, there are exceptions to this rule. The exceptions being the effects of silence. A party normally cannot accept a contract by remaining silent, as expressed in Feldhaus and Binley, where it was established that silence alone does not constitute acceptance of an offer, and that there must be some confirming action or communication from the offeree to specify acceptance. Waiver of communication. Generally speaking, an offeror cannot force an offeree to accept an offer. However, it is possible for the offerer to waive the requirement for acceptance. Waive meaning to give up or relinquish a right or claim. It implies a voluntary decision to forego something that one is entitled to. This means that the offerer takes on the risk of being bound to a contract even if the offeree does not actively agree. This can happen through express statements or implied conducts, as shown in the case of Carlisle and Carbolic Smokeball Company. The postal rule. Acceptance takes place immediately when the letter is posted. Supporting cases for this being Adams and Lindsell and Household Fire and Carriage Accident Insurance Company and Grant. The correct postal methods must be used. For instance, letters being placed into a post box or handed to a person authorized to receive or collect letters. This is supported by the case of London and Northern Bank. The postal rules can be excluded. The rules will not apply if excluded or if the offerer specified another method of communication. This is supported by Holwell and Hughes, 1974. Modern-day contract law is faced with faster modes of communication, for example, telephone, fax, and most commonly now email. Question remains, should the general rule of communication apply or the postal rule exception? These following cases have addressed modern-day communication issues. Feel free to research them.